So I'm releasing this today on September the 3rd, and September 3rd is my birthday. And so this is my birthday bonus to you. I'm going to take the day and spend it with my wife. But I wanted to have a little something out there to sort of celebrate with. This is an interesting case, and I'm going to try and follow it as long as Court TV keeps putting it on. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to look at opening statements in the Caraway murder trial in Kentucky. And it's an interesting case, and it's that the opening statements are interesting for a couple of reasons, but I think most importantly because of the differences in style between the prosecutor and the defense attorney. If you find this kind of content interesting and you're so inclined, please do subscribe. I think that it does help me with the algorithm when people do that. And if you get to the end of this video and you liked it, I'd appreciate a thumbs up. That said, let's get into the opening statements here. The prosecutor leads off, and her job is to tell the jury what the facts are going to be. But just like any good plaintiff's attorney, you want to take the sting out of any facts that are good for the defense. In a typical plaintiff's case where you might have someone who, for example, was arrested 5 years ago for smoking marijuana, something that's not considered to be that big a deal now, but at the time it resulted in a misdemeanor and a slight jail sentence, and that's going to come out on cross-examination, you mention it in your opening. Now, my client, he's not an angel. He had some trouble a couple years ago. He got arrested for marijuana, and he paid his debt to society. But none of that has anything to do with what's going on in this case. And then you move on. You take the sting out of whatever bad facts you have that are against you by getting them in first and minimizing them. I'm not afraid of these facts. Look, I'll tell you the truth. I'm going to tell you the truth about my client. We're going to have to wait and see if the other guy is going to tell you the truth about his client. That's the whole strategy, and that's the whole thesis behind sort of defanging the snake on the other side. You want to make sure that nothing that's going to be hurtful to you comes in for the first time from the defendant's lips. The other thing that you want to do, particularly if you're a prosecutor, is you are the voice of justice. You are here to speak, in this case, for the dead. You are here to bring justice for her family. A young lady taken from us in the prime of her life when she was just getting into her own. That's what you have to be. You have to be confident, and you have to get that message out to the jury. You are there to do justice. Now, as you watch this first little bit of the opening, I want you to measure, if you can, sort of in a non-scientific way, how confident this person is and why it is that she keeps repeating things. Take a listen.
A person should never drive a car while they are under the influence of alcohol. A person should never drive a car while they are under the influence of alcohol and going 80 plus miles an hour. A person should never drive a car while they're under the influence of alcohol, going 80 plus miles an hour with an unrestrained front passenger. The defendant, Bradley Caraway, did all three. On August 6th of 2015, 25-year-old Shanae Mormon should have returned home from a night out with her friends. She should have woken up in her bed at her mom's house. She should have thought about the great time that she had at the concert that she attended the night before. She should have had a normal weekend. Instead, Shanae Mormon was ejected from Bradley Caraway's 2014 Honda Accord as he lost control of his car, ran off the road, flipped the car on its roof. Shanae, thrown out of that vehicle, she was trapped underneath 3,000 pounds of mangled Honda. The car laid on her chest. It restricted her breathing. She slowly lost oxygen and blood to her brain, and she passed. The defendant, Bradley Caraway, walked away nearly unscathed. So Kenneth McPeters is taking this ramp here. He notices a vehicle in the ditch, and Kenneth McPeters, being the good Samaritan that he is, he stops, he backs up on the ramp, and he goes to make sure that everybody is okay. Officer Woods dispatches for EMS, fire, and again, within minutes, all of those agencies would arrive. But Officer Woods walks around that Honda and he is looking for any occupants of the car. Obviously, there's an overturned car. Somebody must have been in it. So Officer Woods walks around and he eventually notices legs sticking out. With the assistance of Kenneth McPeters and a couple of the other men that were on scene, they push the car up just a little bit so he can pull out the legs that are sticking out from underneath this Honda.
Any of you who have ever listened to a talk radio program, and more specifically to the commercials on talk radio, you know that whenever they give you a phone number, they give it to you 3 times. And that's because there's some research that says when people hear something 3 times, they can retain it. And so when the prosecutor is doing this little dance with a person should never drive a car while they're under the influence, and then adds the speed, and then adds the unrestrained front passenger. All of that is designed to essentially be a memory device for the jury as they go through and listen to the facts of the case. What's interesting about it is, if a person should never drive a car while they're under the influence, what does it matter what the speed is? A far better way for her to put that would have been this: a person should never drive a car while they're intoxicated. If a person decides that they must drive a car while they're intoxicated, which is a bad thing to do, then they certainly shouldn't go 80 miles an hour around curves. And if they go 80 miles around curves and they're driving while they're intoxicated, then certainly they should make sure that their passengers are restrained. And unfortunately, Mr. Caraway here, he drove 80 miles an hour while he was intoxicated, but he didn't make sure that his passenger was restrained. Now, it's interesting to me that she took the other approach. I guess that's me being overly picky about style, but style matters, and it has a large part to play in how persuasive someone's argument is. This is someone who is up there and they're basically reading a script. You can tell that if you look. She looks down and she picks back up with her story about, going to the concert, coming home, sleeping in her mom's bed, all of that. All of that was written out ahead of time. None of this is off the cuff. And that's okay, but you really shouldn't do that in an opening statement. You should speak from the heart, because if you don't gain credibility here, it's going to be really hard for you to gain it the rest of the trial, because you'll be asking other people questions. So contrast, if you will, the style of the prosecutor with this rather hard-hitting style by the defense attorney. Let's watch.
Good morning, ladies and gentlemen of the jury. Ladies and gentlemen, Bradley Caraway is not guilty. And some of the most important facts in this case you never heard in that opening. Right at the beginning, I'm going to acknowledge to you the tragedy of this case and acknowledging the grief everyone feels, including Miss Mormon's family. But there's truth to be had in this case. There's a truth as to who was driving. There are facts, there is science, there is DNA, and they all point one way. And the truth is, Bradley Caraway was not driving the vehicle when it crashed. Now, let's begin. Let's go back to the night of August 5th going into August 6th. Shanae Moorman goes out with friends. As you've heard, she goes to 4th Street, then goes with friends to the Tin Roof. From the Tin Roof, she, for whatever reason, decides to split up from her friends, and she goes to Gerstl's, Frankfurt Avenue, St. Matthews. She's at Gerstl's. She and Mr. Caraway meet each other, drink together. All right. Some may assume that because Mr. Caraway's older, he was the one who was, I guess, initiated or was aggressive in the interaction. But in fact, ladies and gentlemen, we'll show you that that is not the case. Both were, Mr. Caraway was intoxicated. Miss Moorman was intoxicated. The medical examiner did a toxicology on her. They're both drunk, and they leave together around 2 a.m. Now, ladies and gentlemen, when they leave, again, you don't have to take my word for it. There is video at Gerstl's, and you're going to see it. We're going to play it, but you'll see how they leave and who seems to be in charge and who's leading who out of the bar.
Did you see what he did there? First words out of his mouth, Bradley Caraway is not guilty. The voice of confidence, the voice of absolute certainty. He is not guilty. And he tells them, you didn't hear all the facts. And then he tells them what the prosecution never even hinted at, which is Bradley Caraway wasn't driving. And that's a pretty big fact to have omitted. I think that if I had been the prosecutor, I would have said, now, defense is going to tell you that, this young lady was driving, but we don't believe that's true. We believe our facts support a different conclusion. But they didn't do that. And so now these jurors are like, whoa, what are we here for if she was driving? And she's the one who died. She's at fault. So almost immediately, from the very get-go, he establishes reasonable doubt. And then, as he goes further in his opening statement, he drives a few nails into the state's case. Watch this.
I mentioned there's scientific proof. There's going to be evidence in this case, data, analysis. And I'm going to set it out to you. Police go and they have the car swabbed, okay, various parts of the car where they think there's blood, okay? And then they send it to the Kentucky State Police Crime Laboratory. That lab tests for the entire state, for police here, for police across the Commonwealth, for prosecutor's office, for Commonwealth attorneys. They do the testing. And Kentucky's had the ability to do DNA testing for years, okay? So one of the places that they found blood was the passenger side airbags, okay? The passenger side airbags. That's blood on the airbags. Passenger side. All right? And the reason they wanted to test that blood is because they wanted to see who's sitting on the passenger side. All right? The airbag only deploys when there's the accident. There hadn't been an accident before. So this is from the accident. And they took it because they say whose blood's on the passenger side, that'll show who's on the passenger side. So the Kentucky State Police Crime Lab tests the airbags. They test the blood on the front of the airbags, and they test the blood on the back of the airbags. They have Bradley Caraway's sample so they can match. And you know whose blood was on the front of the passenger side airbag? Bradley Caraway. You know whose blood was on the back of the passenger side airbag? Bradley Caraway.
I have to tell you, I think the defense attorney is very good here. One of the reasons he focused on the airbag, and you heard him say it there briefly, is that the airbags don't come out until there's an accident. So when there's blood on those airbags, that is the blood that came out of the accident. And the reason that's important is that this is Brad Caraway's car. You would expect to find his DNA on the passenger seat. You might expect to find it on the passenger seat belt. But the only way it gets onto the passenger side airbag is at the time of or shortly after the crash. So either Mr. Caraway, who is admittedly drunk as a skunk at the time this is happening, is such a great master criminal that he remembered to rub his face all over the airbags before he left. I find that pretty difficult to believe. I think what the evidence is going to show and be pretty persuasive about is that he was probably the passenger and belted in, and that's why he survived. She was driving, she was not belted in, and she was ejected. We haven't heard all the evidence yet. We don't know what's going to come in, but generally speaking, lawyers don't put forth evidence in opening statement that they can't back up. And you didn't hear any of that from the plaintiff's side. Now, I didn't play a lot of the plaintiffs because she basically went through the facts of the accident from her perspective and the police investigation from her perspective. But there are all kinds of problems that the defense points out. They didn't preserve the crime scene. They made an initial jump to the idea that Bradley was driving, and they never pursued any alternative theories, and as a result, they kind of got stuck in one direction, and so they're hammering the square pegs into the round holes. That's the whole defense theory. Now, maybe the evidence will come in differently, but at this point, if I was on that jury and I had to vote, I'd be like, why didn't you tell me about the DNA? Why didn't you tell me there was an answer to this DNA on the airbag thing? You should have told me that it was there and that you had an answer to it, but you didn't do that. And so I have to believe you're not being completely candid with me. Again, that's just my take on it. You may have a different view, and if you do, put it in the notes down below, comments down below. I'd love to hear it. After all, this is hopefully a little bit of a discussion about something that's fairly interesting, and the guy is on trial. He'll spend a long time in jail if he is convicted of this crime, and at least in my mind, the fact that there's his DNA in the passenger side airbag, that alone establishes reasonable doubt, but we'll have to see. So that's what I have for you today. Today, you will no doubt, if you are in any kind of a big city, go by someone who's homeless, go by someone who's begging, go by someone who is panhandling. Now, you might very well take the approach that they're probably making more money than people working minimum wage because people hand them money. You might take the approach that they're using it to buy beer and they're laughing at you after you leave. And that may be true, but you don't know that. And as a result, I tend to give to those people not a lot of money, but at least enough to get a hamburger at McDonald's, because the idea that someone would go home at the end of the day hungry, I have trouble with that. Do something nice for somebody today. It'll make you feel better. Have a terrific day. Catch me down at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.